I can at least feel there and see what's up.
Oh, right.
FC,
I think we can get that.
what's that? We're ready? Okay. All right. Just a moment. So I have 24 CV 52569, 25 CV 16784. And both of those matters are entitled Joe Bong versus Douglas County School District. I am prepared to rule on the 24 CV 52569 motion for dismissal. I do believe there is some outstanding things in 25 CR or CV, 16784 that we'll need to address, but I'll get to my ruling first. So in 24 CV 52569, Mr. Murgerow has filed a motion to dismiss on the basis of discovery sanctions. And the nature of that was such that Mr. Murgerow is alleging that Ms. Bong is failing in some respect to provide the documents that are responsive to his requests. And at the hearing, the particular language that Mr. Murgerow described, well, I don't want to say language, the particular documents that he described, or whatever documents that are in existence that are the basis for the quoted language in Ms. Bong's amended or original petition, and to some extent in her amended petition. And so what the court did was went back and listened to a number of the hearings on the motion to compel. And here is what I took away from those hearings. On May 7th of last year, there was a hearing on a motion to compel. And the court, I think, determined at that point that there are at least some unknown number of documents that exist, but they were in someone else's possession, and that person being frequently referred to as Ron Thompson. At that hearing, Ms. Bong attributed at least part of her lack of responsiveness to what she characterized as an ambiguity in the request for production. Ms. Bong additionally claimed that the documents sought with respect to the public records requests were irrelevant. At the conclusion of that hearing, the court granted the motion to compel. 6 or 7 weeks later, on June 30th, there was a hearing, and at that hearing, there was an effort to clarify particularly the scope of the requests. Mr. Murgerow was asked by the court what it is that he wants. He stated that all he wanted was the public record request that she submitted, so she needs to provide, or that she submitted, and that was supposed to have been provided within 14 days of the May 7th hearing. The court acknowledged that presented an issue because originally, while the court did, the court granted the entire motion to compel, but at that particular hearing, I think there was some confusion because of the idea that there may only be a singular document that was actually in existence. And the court specifically said it isn't the court's intent to narrow the scope or the request for production, but I expect that the document, and that being this actual public records request, be provided to the defense. The court then asked if there was a need for additional clarification, and Ms. Bong sought to understand whether she would be required to obtain communications between, quote, Ron and the school because she never actually contacted the school. The court then again asked Mr. Mergereau what he was looking for. He responded that all he was after what was quoted in petitioner's complaint. So at the very least, on 30th, there was the identification of these quotations in petitioner's complaint that are the bases for this whole case, and that was all that Mr. Mergereau was after. The court then asked petitioner if she understood what Mr. Mergereau stated, and she asked him to repeat it. Defense reiterated that the complaint states that, quote, you via your friend made a public records request. Your complaint quotes liberally from communications between either you or your friend, and it's those communications that I'm after. So at that point, at the very least, we're understanding that this isn't relegated to a singular document, but there's a more expansive request that was clarified at the very least on June 30th. The court reiterated that after some further attempts at trying to identify the particular documents that Mr. Mergereau was after, and I don't think that there's any duty for Mr. Mergereau to identify particular documents that he may or may not even know the existence of. But the court reiterated after attempts to get Mr. Mergereau to identify further that the court said, I'm not sure Mr. Mergereau is in a position to determine what the actual particular document is. That reminded Ms. Bong that she's the one who brought this case, and you're the one that's alleging that there were communications to the school district that constituted this request, whatever those are. And reminded her that the court can't tell you what they are either. Mr. Mergereau can't tell you what they are, but whatever those are the basis for the request, and those are what need to be provided to Mr. Mergereau. We then came back on August 4th. Petitioner stated that she had not complied with the order because it was only a verbal ruling and not an order. The court clarified that it had in fact ordered production of the documents back on May 7th and reiterated that on June 30th. At the conclusion of that hearing, the court confirmed that it would be signing the proposed order and I believe it was signed that particular day and uploaded to the register the following day. In response to that confirmation, petitioner says she would consider it signed, the order, and send no contract counsel his documents. And that's part of where the nature of why this is going this way, because whether or not there is a court order doesn't hinge on the party's understanding or consideration thereof. When the court orders something, it is an order, regardless of whether or not it has been considered an order. On August 5th, the order was entered into the record, and that required production of documents, requests 1 through 3, including all documents comprising the public records request at issue in this matter within 14 days. And I believe it was actually, I'll pull it up so I'm accurately stating that. The order, states that Yes, the court being fully advised in the premises, it is hereby ordered that the defendant's motion is granted and plaintiff is ordered to produce the documents requested in defendant's request 1 through 3, including all documents comprising the public records request at issue in the matter within 14 days of signing of this order. So at the very least, there was, giving all benefit of the doubt, even if you wanted to say that this order hadn't been signed until August 4th, it was signed on August 4th at 1:35 p.m. So then, several months later, on December 29th, the parties came before the court on a hearing on this motion to dismiss, and the basis was that Mr. Mergereau had received a singular document, but Ms. Bong was continuing to refuse to not provide additional documents, which are the basis for the case as they are quoted in her petition. So at this point where we are, and I'll note that at that particular hearing, Ms. Bong acknowledged that the documents that we were referencing were most likely in writing and continued to say that she didn't have access to them. In this ruling, I think it should be noted that the court has considered petitioner's pro se status quite extensively. The court is also aware that Ms. Bong has litigated several matters of similar nature without representation and is informed of many legal processes and procedures beyond what the court would expect from a typical pro se litigant. Given the nature of how these proceedings have unfolded, particularly with respect to the motion to compel, and that petitioner, at least on December 29th, had still not complied with the court's order on the motion to compel, the court finds that petitioner's failure to comply with the order is willful and in bad faith. Dismissal is the ultimate sanction for conduct of this nature. And so the court is not actually going to make, I'm going to say the court is not actually going to dismiss this case at this point, but however, the court does believe that there are other sanctions that are appropriate, and those will be as follows.
Okay.
Mr. Mergereau is to submit a proposed amended petition showing the operative language related to the discovery misconduct that Mr. Mergereau believes should be stricken for failure to produce these documents. From there, the court will decide the appropriateness of the demonstrated amendments. Ms. Bong will then be allowed to replead in congruence with the amendments deemed appropriate by the court. Anything that is repled beyond the scope of what the court has determined appropriate will constitute further willful misconduct and will likely result in the entire pleading being stricken. In addition to this, the pending motion for summary judgment is denied, and the court is hereby ordering reasonable expenses, including attorney fees, incurred in obtaining this order. The documents that are quoted are the documents that are the subject to the motion to compel that have not been provided to the respondent in this case will also be deemed inadmissible as offered by petitioner. Is there anything else?
Your Honor, I believe I understand your ruling in the 24 case. The court also called the 25 case Do we have matters to deal with in that case?
So that was one of the things that I was actually wondering, based on the posture of previous issues that have arisen from a similar nature. What I have before me and is a motion to compel production that is with respect to a subpoena, and I think there's two of them. One to Craig Zalezi Insurance, and the other is again to a Jensen. I don't remember the first name. Jens Jensen at Pace. And so previously those there were similar pleadings that were filed with the court that I believe Mr. Murderow was not notified of. And so one is, it appears to me that the certificate of service indicates that you have been provided a copy of these documents. Is that true?
I have both the motions to compel, yes, Your Honor, but I don't represent either of the subpoena recipients. The certificates of service will note, at least on one of them, that the lawyer for Mr. Zalezi was served with the motions. I'm not sure if there's been a response or not.
I do not perceive a motion or a response on either. And so I will figure out what to do with these. Ms. Bong, did you have anything you wanted to say with respect to 25 CV 16784 while we're talking about it?
I do not believe so. The subpoenas are pretty straightforward. They have not filed objections within the 14 days and have not produced within the 14 days. So it's pretty cut and dry in terms of that. Okay. But I would like to go back to the case ending in 6.
Go ahead.
6-9.
I can't. You broke up a little bit.
I do have a pending motion to compel.
You're breaking up, Ms. Bong.
I'm sorry.
I think she was referencing a motion to compel
of the
that she filed
instruction records for the case.
Yes. Do we need to set a hearing for that? I don't think there's a response from Mr. Murderow, but do we need to set a hearing?
Well, Your Honor, I actually have a matter I'd like to raise with the court, which is that I'd like to set trial in both of these cases. And I'd like to do that fairly quickly. The 24 case obviously has been around for a long time. Likewise, the 25 case, I believe was filed in early. Ms. Bong, just give me 1 second, please. There is a part of the public records statute, 192431, section 2, requires that these matters be set at the earliest practicable date and expedited in every way. We're probably a little bit beyond expedited here, but I think it's time to get these things over with, Your Honor. We can be available virtually any day in March, except for the week of spring break, which is the week of March 23rd. These can be set for a one-day trial, one-day court trial. We can get both of them done in one day. They're extremely simple matters. They're both the same parties. I don't see any reason why we can't try them together. The number of witnesses and the number of exhibits will be quite low. The issues before the court will be fairly simple. And I think it's time to get these cases decided, Your Honor.
I agree. I think the delay has been the voluminous number of issues that have had to be decided by the court in this particular 24 CV 52569 case. And so I do agree that we need to get a trial date on the record. I think my preference would be to have my staff email you. The court is currently going through some case reassignments. And so this court's calendar is likely to open up in the very near future. And so what I would like to do is have you all communicate with my staff via email about those dates, and we can get a date set.
That would be great, Your Honor.
And this will be a bench trial. And I also am, but I think we need to figure out what this issue is of the Ms. Bong has a motion for, well, it just says production of destruction and record management documentation. Ms. Bong, what is this? Is this a motion to compel? It looks like it is.
Yes, Your Honor. Before we go on to that, I would like to raise my objection again. I have asked for jury trials on both cases. There are material issues of fact at question, and also there are damages requested for the case ending in 6-9.
Okay, so, and I understand, and your objection is noted. Okay, but Ms. Bong, you're breaking up, so I'm having a difficult time hearing you. I think what I want to do is,
Can you hear me?
I can hear you now.
Okay, so the motion to compel the destruction of records is related to the ORCP motion that the defendant filed for sanctions. It requests the destruction of records of the so-called emails that I allegedly am withholding. These records are required for permanent retention by the district under administrative rules for school districts.
Okay, so do we need to set a quick hearing on this?
I suppose
you intending to,
Your Honor.
Was what it was retaining.
What's that, Mr. Murgero?
I said, I suppose we could set a hearing, or we could try to deal with it now. I'm not sure what, how the court wants.
I'm having trouble. The only problem is I'm having trouble with Ms. Bong's connection.
Yeah.
I'd be happy to hear argument now if we could, but we can even come back as early as sometime this week when Ms. Bong has a better connection. I think
that's fine, Your Honor.
Yeah.
Can we try?
I'm going to have my staff reach out
now?
to you, and in that email, we're going to accomplish two things. One, setting this for a brief hearing this week, and two, getting a trial date on the calendar.
Sounds good, Your Honor. Thank you, and I'll prepare an order.
Thank you. Have a good day.
You as well.
Can we hold on? Could we order to get the motion to compel?
That's bullshit.
Ms. Bong, can you hear me?
Can you hear me?
Yes. Ms.
Can we
Bong,
hold off on the order until you hear the motion to compel destruction of records?
well, he can prepare the order, and if you have an objection to it, we can deal with it at that time. But my staff is going to email you to have set a hearing and to get trial set.
Thank you, Your Honor.
Have a good day.
You too.
You wanted that this week.
If we have time.
We do.
Yeah. I mean, that works with everybody's schedule.